and Professor Rainer Arnold is going to talk about peace and security through international law. Please, floor is yours.
Dear colleagues, ladies and gentlemen, first of all, I want to thank cordially to Professor Tatiana Murawska to have invited me to this highly interesting conference, and also to Professor Žaneta Ozoliņa to have accepted me to this, for me, very interesting panel, hard power, soft power, smart power. So I don't know so exactly what law is in between, but has elements of all these aspects. My perspective is a legal perspective, not a political one. Of course, the political perspective is the most important in this situation, but however, nevertheless, we have also sometimes to have looked to the law, and you have done this also in the context of your political perspective, was very right. So my subject is a very hard subject, let's say, difficult, and it's not possible to treat all the aspects I proposed by myself, this subject, and so I want to reflect with you together on some of the items connected with this subject. Well, first of all, I want to explain that law is something which gives peace and security on the national level, on the international level, and in particular, and this is my accentuation, law concerning human rights. Well, law constitutes an order. Law is binding, so that this order is a stable order, stabilization by a normative effect of law. And this order must be and is normally an harmonious order, a peace-related order. Law creates peace on all the levels regular, and has to defend peace, what is important. Well, harmonious means that this legal order, as it's created by a constitution, for example, has a tendency to reconcile all the interests, the basic interest in a certain society. And this is, of course, in particular applicable and valid in the national legal order, because this national legal order is very different from the international legal order. The national order is based on a institutionalized power exercise in a vertical sense, means state power exercises legitimate normative power on the individual. It is vertical, while the international community is based on coordination. It's based on sovereignty of the legal subjects of international law of the sovereign states. And so this is a coordination system which has deficits, of course, so that the upkeeping of peace and security is much more difficult than in a state system. Well, let's go back to the state system. State system and the law system shall be harmonious, as I said, and wants to reconcile possible conflicts, and has a tendency to avoid conflicts. And if there are conflicts, they will be resolved by law and by independent legal institutions, which are called courts. All this is not so clear on the international level. Of course, we know that there is an International Court of Justice, and This International Court of Justice is essentially based on the notion of sovereignty, so that the states are the parties and they have to give their submission, their consent, which is an expression indeed of sovereignty. This is quite different in more consolidated systems such as European Union, for example, which is much more state-like than the international community as such. But, well, to constitute harmony between the subjects of a community within a state, and for this to constitute an internal state peace, and to keep this peace up and to stabilize this peace, this is one of the main finalities of internal law. Why can internal law obtain this finality, fulfill this finality? I think because there is a consensus in such an harmonized system as a state is. Maybe not all the states. Multi-ethnic states have much less consensus than relatively consolidated, also ethnically consolidated states. And so I would say that in general, equality and the abstract character of law contribute to the consensus. A consensus is achieved by transparency and co-determination. Transparency, democracy, parliamentary debate or extra-parliamentary debate, discourse of daily politics, this leads to this consensus. And I think consensus is important for the satisfaction of the individual and satisfaction, well, of the needs in a larger sense of the individual, and satisfaction of the members of the community of these individuals, the society. Well, and there are and must be conciliation mechanisms within this state power or this state system, reconciliation, because conflicts are not to avoid, and they are relatively easy to overcome in a state system, in contrast to the international community as such. And I want to refer, having first a look to the national level, also to the role of the individual. The role of the individual in the state system today is that what I would call an anthropocentric approach of state power. This is in democratic states, in pluralistic states, in the contemporary structure, is a very basic tendency. Contemporary law in these, I do not speak of course, of quasi or fictitious democratic states, which call them democracies but are not, but real democracies that the anthropocentric approach is the very basic finality of a constitutional system. And this is very significant in constitutional law, because constitution is the legal basis of a society. And here we see that increasingly constitutional law is promoting and is let's see, referring to human dignity, to fundamental rights. Fundamental rights are conceived as orders, let's say, orders of values which are complete, which have to be extended by the constitutional judges to cover all the dangers coming up, present or in future. And they have to be functionally effective, and they are in particular interconnected with international human rights. Today, a state system is anthropocentric. This means it's based on the tendency to individualize this system. It is based on a new concept of rule of law, which means constitution is the primary concept, and constitution has to be related with values, with human and individual right, and this state system is internationalized. Well, individualization of law, concentration on the individual, this is highly peacekeeping and highly stabilizing. And so on the internal level, within a state, the respect of the individual and its rights and rule of law, the respect of law are the most important pillars of this system. Well, as I have already pointed out, we cannot transfer all these elements from a state to the international community. The differences are very striking, but nevertheless, though stabilization and peacekeeping is much more difficult in international system, in international communities than in national systems, but I think that some of the elements we have stated in this very short analysis on the state level can be transferred indeed to the international level. First, I want to say that we have also here a tendency of individualization. We know all that the subjects of international law are the sovereign states and maybe communities of states as they associate to international organizations. But the individual is not a traditional subject of international law, but increasingly the international law goes on to individualize. States have created a universal not only declarations, but also binding treaties, covenances, and many particular treaties on human rights. And this is a return, or is now a new perspective of the respect of the individual. And even if the legal subjects, the sovereign states, are behind these treaties, and violations of human rights are violations of the legal subjects, the states, but nevertheless, these international treaties have become a part of what we call jus cogens, of some say even a constitutional order of in international law. So that internationalization is now in part also a process of constitutionalization. However, I must say that sovereignty, existing sovereignty, even sovereignty is very limited in our times. Sovereignty reduces the possibility to individualize and to create peace and security from this standpoint on, seen from the individual. But let us nevertheless ask what is peace and security guaranteed by human rights, by international law. Peace is not only the absence of war, it is also a positive process. It is development, economic development, development also of law and of the respect of law, to take serious the principles of international law, in particular the prohibition of use of military force or of threatening the force, and to take international law seriously, not to circumvent law by target interpretation of the real situation, and to abstain from manipulation of media by disinforming the public and by interrupting the process of democracy, which relies on reality, not on fiction, and not on targeted selection of information. Well, peace through international guarantees as they exist is very important, but also peace must be done by peace work and by the promotion in particular of human rights. Human rights and peace are very closely connected. without a respect of human rights, a real peace cannot take place. And so I would say that the promotion of human rights is also something what we should take into account in our analysis, because the respect of law, not to hide the law behind targeted solutions, and to respect the individual. Lastly, the individual is the subject which suffers from such events as we had them in the last history. So I wanted to contribute a bit to make evident, or to wake up a bit also the let's say the tendency and how important human rights are for the peace and security process. Thank you so much.
Thank you very much. Thank you indeed, and thank you for bringing legal and human rights dimension into our discussion, because values, norms, basic principles are of particular importance when you are at the crossroads, and then not to lose the light and direction, you need those basic principles. So thank you very much indeed for your presentation. And when you asked him at the beginning the question whether law is soft power or not, I should say that law is soft power with hard edge, referring to Jānis Kažociņš title of the presentation. Dear participants of the conference, now the floor is open for questions and comments, because unfortunately we have only 15 minutes for Q&A session, so therefore without any further delays, I immediately see hand over there. We have assistants with mics. They will approach you, and please identify yourself before asking questions.
Hello, dear colleagues. Professor Yulia Sushkova, Magdovia, Ogarov State University, Russian Federation. First of all, I would express my gratitude to Professor Muravsky for inviting me to participate in that conference. And of course, I cannot, since I'm the only delegate from Russian Federation, I want to make some remarks on what I've heard. Well, I think for last quite some time, in regards of Russia, we hear the terminology like violation of international law, aggression, annexion, the necessity to use hard sanctions, Russia's propaganda, and terminology that goes this way, and we can continue. And the conference today also proves that these ideas are very vivid now in Europe. Actually, I was catching myself on the thought that we are coming back with all the terms to decades ago, when actually maybe now we entering the period of even harder than the Cold War period. Even though at that time I wasn't even born, but I have read and got acquainted with lots of literature on this. And of course there is a big question how perspective is to think this way. And as the last speaker was telling, that we need to respect law. And actually, in fact, according to the international law, none of those facts that could prove that attitude of Russian Federation has been proven. Even more, if we're talking about so-called, in quotes, war in Georgia 2008, it was proven by an international organization who has, in fact, started that war. And it was proven by OSCE and Council of Europe, and even within Georgia, certain facts has been. And we are talking about the influence of Russia.
I'm very sorry, as a moderator, I have to interrupt because we have 15 minutes.
Okay,
so
2 minutes.
Just could you please sum up and ask
Yes.
question whom you would like to address?
Another thing, we're talking about the influence of Russia in Eastern Europe, in the eastern Ukraine. Nobody has proven those facts as well. So I believe it also agree with one speaker who said that states and people have to decide themselves. 5 million of Ukrainians work in Russia and live. Here, when I walk along Latvia, most of people speak Russian language. We are connected with the Eastern partners for years, living together in one country over 70 years. We are connected historically, culturally, and those bonds are very important. I agree with one position that today, in the first part of the day, the Minister of Foreign Affairs stated that all countries now in a very hard geopolitical struggle, and this is maybe some objective idea. But anyway, since we have a lack of time,
Yes.
I have a question.
Yes.
Do you think this attitude and this rhetorics is perspective for the future, for collaboration between Russia and EU with European countries? We also know that business elites of each member state of EU
Okay,
does
whom
not
you are
support
targeted?
this
Whom you are targeted this question?
I think I want to ask Janis, Professor
Okay.
Kazachins.
Yeah. Okay, thank you very much. Yeah, so sorry for interrupting. I would like to allow you to go for more and more, but unfortunately, the time is really running out. So, Jans, please.
Straight away. Thank you very much. To be honest, I think it would have been very useful to have you on this panel as well, because we are too often all speaking in the same direction. And it is a basic principle of democratic societies that you must listen to the other point of view as well. And for that reason, I think well, I'm glad you are here, at least you are one, but I would like to see more representatives from the Russian Federation. Having said that, in direct answer to your questions, first of all, I think there is little dispute that the 30 coffins which went out with the Red Cross and Cargo 200 were bodies being repatriated to Russia. So directly or indirectly, Russia is involved in eastern Ukraine. As far as rhetoric is concerned, I think it is very important that different points of view are heard. And for that reason, I personally do not support the restrictions placed on one Russian channel in Latvia. I absolutely agree with President Ilves of Estonia, who says that he would not accept any kind of censorship. At the same time, in the Russian Federation, we see that a free press is being suppressed, and anyone who speaks or broadcasts in ways which are not conducive for Kremlin's foreign policy find it extremely difficult to continue. And you know the story with Dozhd and Letteru and so on. There are a lot of these things. I would very much like to see a broader availability of Western or different points of view available to the Russian people as well, because I agree that rhetoric of this kind will not be a good thing, and it's particularly dangerous if only one point of view is heard.
Yeah, thank you very much. Yeah, here are also two responses from Eka and then from Ambassador.
From the very beginning, I wanted to note once more that we are for constructive cooperation with Russian Federation. We want Russia to be deeply interlinked with the region, with economic cooperation, and so on, so on. But I wanted to note two statements from the Russian side, and then judge yourself. On 16th of April, Karasin stated during Abashidze-Karasin meeting, its new format of our cooperation with Russia, that Russia does not intend to interfere with the signature of association agreement between Georgia and the EU. But On May 22, Russian Foreign Ministry spokesman Alexander Lukashevich stated that it is very important to understand consequences to which the upcoming signing of the association agreement between Georgia and the EU may lead. So it's a reality. Thank you.
Thank you. Marius.
Well, thank you so much. Very briefly, I would say that I find very unfortunate that we are in this situation in relations with Russia, because I think the European Union and NATO, just mentioned those two organizations, during the last 2 decades have produced a number of initiatives, projects and programs to develop very constructive relations with Russia. Let's name just Partnership for Modernization by European Union, or this I already mentioned during my intervention, NATO-Russia Council, which has no precedent in relations to any other of our partners. But you have to understand the simple fact that these days, by using military force and intimidation to change the borders in Europe is not just acceptable. And the Western community will not simply accept that and continue to have the dialogue with Russian Federation as nothing has happened. So I definitely believe that the ball is in Russian court, and you have to decide the way forward. And just one point with regard to Georgia, you mentioned 2008. Of course, I like those different views on who started, who made the first shot, etc., etc. But let's admit, not a single shot was made during those events on the soil of Russian Federation. All military activity happened on the soil of Georgia, of sovereign nation. So therefore, I would refrain in using that argument in your future interventions. Thank you.
Okay, thank you. More questions? Yeah, here, please. Lady over there.
It is not question, it is some opinion. I think that Ukraine has great potential to be free and rich country. And I think if Russia stopped so strong influence on political field of Ukraine, we reach this goal. And I see a future of Ukraine in Europe. But from other side, I think that Ukraine must collaborate with all countries of the world. Thank you.
Thank you very much. Yeah, please. Here.
Yes, Alexander Berlin. I have a question to Professor Reiner regarding international law versus national laws in the human rights. Where do you fit in that context the European Court of Human Rights of the Council of Europe? Because their member states don't have to give their agreement to be considered for a case to be. And I'm thinking particularly of the case of Öcalan in Turkey. So in that case, it's already it's established that the European Court of Human Rights does not have to consider the points of view of the countries concerned. So where do you fit that European Court of Human Rights?
Yeah, here's the microphone for you, Arnold.
Yes, thank you for this question. The European Court of Human Rights in Strasbourg is not an international court in the traditional sense. It is, I would say, it is on the way to a constitutional court, a European constitutional court, and the court itself says that the European Convention of Human Rights is a sort of constitutional instrument of a European order. And here we have indeed the accession of the individual directly, a direct application, and the member states are, they have no sovereign right or no right to say no. Clear, they are, with ratifying the convention, they have submitted totally to this jurisdiction. So this. What do you feel is the importance of that court? Yeah, it's highly important. I'm always writing, I think the regional courts are much more important, in particular the Strasbourg Court, and much more, of course, than the International Court of Justice, which has its significance and importance, is clear, but they are really different in the impact. And so I think the European constitutionalism of today is highly influenced by the jurisprudence of the Strasbourg Court. And our Constitutional Court in Germany even has said that it is indispensable to interpret the German, the national fundamental rights of our national constitution in the light of the jurisprudence of the European Court of Human Rights. And so we have an interconnection of both levels, and here I think it is, the structure is constitutional. We have some, of course, some elements of international law, but it is really on the way outside, so to say. And this and the International Criminal Court are new tendencies of leaving behind, maybe, or in part behind, the old style that only sovereign states are subject of international law.
Thank you very much. Dear friends, we have few minutes left. If somebody really is very eager to ask question, your hand is already counted. So, but if somebody else would like to ask questions, this is the moment to raise your hands. Otherwise, you can discuss this topic later on during the coffee break. But if nobody is so eager as I tried to, let's say, to put some kind of force on you, then here is the last question, please.
Hi, Ovidiu Ratio, University of Victoria, Canada. I was just wondering, there seem to be a bit of two different points of view between Mr. Rieknis and Kazocic. While you were stating about Russia's expenditure on defense, and you were criticizing it from the increase from 2001 to 2011, Mr. Rieknis said that a country who does not spend on defense is a vulnerable country. Also a comment on Transnistria. How come, besides the resolution in 2008 from NATO to urge the Russian military to withdraw from Transnistria, is that still a priority, and how do you respond to that, considering that you declared that Moldova is an important partner to NATO and so on? Thank you.
Thank you. It's from Mars. And then, Janis, yeah?
Is it about budget or Transnistria? Well, I have to say that that with regard to Transnistria, this frozen conflict, there is a special international mechanism established 5+2 talks, and NATO is not a primary driver in those negotiations. But of course, I mean, this is academic audience, and I would like to express my personal view. I think that if all parties involved, and here again, unfortunately, I have to say that the Russian Federation is playing its role. If all parties involved, influential, rich, with all foreign policy tools at hand, if they would be really sincere in order to get a result in the negotiations on Transnistria, then I would guess that would take perhaps a couple of months to solve. Perhaps the situation in Nagorno-Karabakh, which is also a frozen conflict, is more complicated, but also there I would like to see more constructive approach from Russian Federation as a part of negotiation process. But on budget, Janis.
Yeah.
You're absolutely right. Any country which does not pay for its defense is going to be vulnerable. There's no question about that. Whether it is reasonable for the Russian Federation to increase its defense spending by such an amount, I would argue no, because the Russian Federation would increase its security far better by spending on economic diversification and improving its infrastructure. Of course, there are risks, and there are risks in the Far East. The Far East, as we all know, all the major players are increasing their defense expenditures substantially, and I mean here China, Japan, South Korea, Vietnam. they're all increasing their defense expenditure. But what we see in the case of the Russian Federation is that it's not in the kind of way which is very easily able to be used for the Far East, though of course all forces can be used in the Far East. But when we watch exercises like the two Zapad exercises, which cannot be anything else than a rehearsal for the occupation of the Baltic states, then of course the question is, well, why is it necessary to do that here? And why exercise something unless you have half an intention of maybe doing it sometime in the future if the circumstances are right? And that is what makes us so very, very wary of Russia, and why we are very disappointed that the dialogue that we have had with Russia for so many years, for the time being, is broken down because Russia has decided to knock over the rules.
Thank you. Dear colleagues, the aim of this panel was to discuss regional security issues, and I think that all of us together, we achieved our goal, because we at least try to identify which are main risks and vulnerabilities in different regional settings, what policies to be applied, and what actors should be involved, including individuals, which are the main actors in international community. So, but as Maris said in the beginning, that regional security very much depends on international system, on the way how different actors perceive the developments on the world arena. And here we need economic, legal, political, and also different humanitarian sources. And when Ambassador started his speech, he said that this is the first time when he gives a speech from this let's say, perspective from this part of the room. And Maris, this is my second time when I'm sitting here. And the first time was in 2003, together with Gunther Verheugen, who at that time was responsible for EU enlargement. And we were both here sitting in front of distinguished audience, trying to explain from EU and Latvian side whether the EU perspective is really worth doing. So really it's worth to join the European Union. I think after 10 years, and now we are celebrating those 10 years, I think this is not the question anymore, because we are benefiting extensively. And that's what we have learned, that what we gained from EU membership, now we are ready to share with our friends in Eastern Partnership country. And now it's time to deliver. So let's deliver all together. So thank you very much.